Welcome to USA Law Explained, where we break down real American law the way your lawyer would explain it to you. Plain English, no confusion, just facts you can actually use. Today's topic is wrongful termination, one of the most misunderstood areas of employment law. Millions of Americans are fired every year, but most of them never find out whether their firing was actually illegal. Stay until the end, because the Action Steps section will tell you exactly what to do in the next 72 hours if you believe you were wrongfully terminated. Identify the legal issue. Let me start by explaining something that shocks almost every client I talk to about this. In the United States, most employees work under what is called at-will employment. This means your employer can fire you at any time, for any reason, or even for no reason at all. And you can quit at any time too. I know, that sounds unfair, and sometimes it is. But here is the critical point. At will does not mean fire you for any reason. There are very specific situations where firing someone becomes illegal, and that is what we call wrongful termination. So the first question I ask every client is this: why were you fired? Or more importantly, what do you think the real reason was? Because the law doesn't care as much about what your employer said. It cares about what actually motivated the decision. The law. Now let me walk you through the legal basis, the actual laws that protect you. Protection number 1. Title 7 of the Civil Rights Act of 1964. This federal law makes it illegal to fire someone because of their race, color, religion, sex, or national origin. This is one of the most powerful employment protections in America. If you were fired and you believe your race, gender, or religion played any role in that decision, Title 7 is your foundation. Protection number 2, the Age Discrimination in Employment Act. If you are 40 years old or older, federal law protects you from being fired simply because of your age. Companies cannot replace experienced older workers with younger employees just to cut costs, at least not legally. Protection. Number 3, the Americans with Disabilities Act. If you have a physical or mental disability, your employer cannot fire you for that reason. They are actually required by law to make reasonable accommodations for you before termination becomes an option. Protection number 4, retaliation protection. This one surprises many people. If you reported illegal activity at your workplace, what we call whistleblowing, or if you filed a complaint about discrimination or harassment, and then you were fired shortly after that firing may be illegal retaliation. Federal law specifically protects employees who speak up. Protection number 5, FMLA, the Family and Medical Leave Act. If you took legally protected medical leave for your own illness or to care for a family member, and you came back to find your job gone, that may be a direct violation of federal law. These are not small protections. These are federal laws with real consequences for employers who violate them. Real-world application. Now let me make this real. Let me give you actual scenarios, the kind of situations my clients bring to me. Scenario 1. Maria worked at a company for 6 years. She got pregnant. 3 months into her pregnancy, her manager suddenly started giving her poor performance reviews for the first time ever. 2 months later, she was fired for performance issues. Is that wrongful termination? Potentially, yes. Pregnancy discrimination is illegal under Title 7 and the Pregnancy Discrimination Act. The timing here is extremely suspicious, and timing matters enormously in these cases. Scenario 2. James is 58 years old. His company hired a new director who started pushing out senior employees and replacing them with people in their late 20s. James was told his skills were outdated. He was fired. 3 people under 35 were hired in his department within 2 months. Is that wrongful termination? Potentially, yes, under the Age Discrimination in Employment Act. Scenario 3. David reported his manager to HR for sexual harassment against a co-worker. 2 weeks later, David was fired for allegedly violating a minor company policy that had never been enforced before. Is that wrongful termination? Almost certainly, yes. This is textbook retaliation, which is explicitly illegal under federal law. Notice something in all 3 scenarios. The employer gave a reason, but the real reason was something else entirely. That gap between the stated reason and the real reason is exactly where wrongful termination cases are built. Now I need to talk about mistakes, because what you do in the days immediately after being fired can make or break your case. Mistake number 1. Signing a severance agreement immediately. When you are fired, many employers hand you a severance package and ask you to sign it right away. That document almost always contains a clause where you agree not to sue the company. Do not sign anything until you have spoken with an employment attorney. Once you sign, your legal options may be gone forever. Mistake number 2. Not documenting everything. The moment you suspect something is wrong, start writing everything down. Dates, conversations, emails, names of witnesses. Courts love documentation. Memory fades. Written records do not. Mistake number 3. Waiting too long to file. This is critical. Wrongful termination claims have strict deadlines called statutes of limitations. For federal discrimination claims, you typically must file a complaint with the EEOC, the Equal Employment Opportunity Commission, within 180 to 300 days of the termination. If you miss that window, your case may be gone regardless of how strong it is. Mistake number 4. Venting on social media. I understand the anger. Being fired feels deeply unfair. But posting about your employer, your manager, or your case on social media can seriously damage your legal position. Employers and their lawyers monitor this. Stay silent publicly until your case is resolved. Mistake number 5. Assuming nothing can be done. Most people who are wrongfully terminated never take any action because they don't know their rights, or they assume fighting a company is impossible. The reality is that employment attorneys often take these cases on contingency, meaning you pay nothing unless you win. Action steps. Here is exactly what I tell every client in this situation. Do these things in this order. Step 1. Write everything down today. While your memory is fresh, document every detail. The date you were fired, what was said, who was in the room, any prior incidents you believe are connected. Save every email, text, and performance review you have access to. Step 2. Do not sign anything. If your employer gave you a severance agreement, do not sign it yet. Take it to an employment attorney first. You may be able to negotiate better terms or preserve your right to sue. Step 3. File with the EEOC. If you believe your termination involved discrimination or retaliation, go to eeoc.gov and file a charge. This is a required first step before you can sue in federal court, and the clock is already running. Step 4. Consult an employment attorney. Many employment lawyers offer free initial consultations. Search for wrongful termination attorney in your city. Bring your documentation. Let a professional evaluate your specific situation. Step 5. Apply for unemployment benefits. Being fired does not automatically disqualify you from unemployment. File your claim immediately. Delays can cost you benefits you are entitled to. Let me leave you with this. Being fired is one of the most stressful experiences a person can go through. But feeling powerless is not the same as being powerless. The law gives you real protections, but only if you act quickly and know what to do. If this video helped you, please share it with someone who needs it right now. Subscribe to this channel. Every week we break down real American law in plain English, exactly the way your lawyer would explain it to you. Drop your questions in the comments. I read every single one. This video is for general educational purposes only and does not constitute legal advice. Every situation is different. Please consult a licensed employment attorney for guidance specific to your case.